The assumptions are faulty. The requirements to rehabilitate someone is just too costly, takes too long. And some people are not diseased, they just did a crime. Okay. I'm going to quickly go over presumption of innocence as a concept and also the burdens of proof. Through each of these crimes, or what we're going to go over this semester, we'll look back to this, so this is more of an overview. Presumption of innocence. Wonderful idea in our society. The criminal, or the accused, I should say, is not guilty until he is found guilty by a court, by a jury of his peers. An accused is not guilty until he is found so under our Constitution. That presumption of innocence is an idea, is a burden on the state to overcome. It's a rebuttable presumption, which means that it can be overcome by the state. But it's a presumption nonetheless. It's where we start from. We start from the fact that person is innocent, and we work our way from there. We do not start from the fact that the person is guilty. Burden of proof is that burden that I just spoke of, overcoming that presumption. It's a rebuttable presumption. The burden is on the state, not the defendant. Under burden of proof, you have the burden of production, and you have the burden of persuasion. The burden of production is evidence. Something has to be brought into court for the trier of fact, the fact finder, to make a determination. That's the burden of production. The burden of persuasion is using what is produced to persuade the finder of fact, usually the jury, in enough way that they will find the defendant guilty. And that standard of proof has a high standard in most cases of beyond a reasonable doubt. Beyond a reasonable doubt. Something else you might hear is preponderance of the evidence. Now, every time you would go into a trial, the attorney would try to convince the jury what the standard of proof is, what the burden of persuasion is. The law will dictate what that needs to be. Murder cases, for instance, anything that is likely to put a person behind bars for quite a while, you're going to have a higher burden of proof. Beyond a reasonable doubt doesn't mean absolutely sure. Doesn't mean exceptionally sure. It just means that if reasonable doubt exists, you must cross it as a jury, as a juror. As a juror, you must recognize whether a reasonable doubt exists. If it does, you must be past that reasonable doubt. That's a pretty high order. On a scale, that's 95% sure. That's pretty high. Versus preponderance of the evidence, which is more than 50%. More likely than not. That's preponderance of the evidence. In civil trials, you might have preponderance of the evidence. In place of beyond a reasonable doubt, you might hear clear and convincing evidence, which is very similar. The defendant will always be able, if there's one available, to come up with an affirmative defense. An affirmative defense is one that gets the defendant off the hook. Yeah, sure, I took that stuff from that person's house. I had permission to do that. Well, that permission means that there wasn't a criminal mindset to steal it. Rather, he was just doing what he was supposed to. So you'd have any number of affirmative defenses to lead the trier of fact to determine whether or not the defendant is culpable. Now let's skip over to the importance of case law. We're going to just talk a little bit more about that. If you're in front of me, I would ask you what recent cases you've heard about that affect criminal laws. Think about that for a second. Which cases have you heard in the news that have affected criminal laws? Roe v. Wade, for instance. Abortion is a crime. Well, the Supreme Court said that abortion is a protected right under our Constitution that's afforded, that exists within women. More recently, sodomy laws. Laws prohibiting various unnatural acts as is listed in many state statutes. Crimes that the Supreme Court said cannot be made crimes. You can see how case law then affects crimes, where once a woman could be put in jail for having an abortion or two men having sexual relations in the privacy of their home could be put in jail for that, that is no longer the case because of case law. So I want you to think about what kind of case law that you've heard about that has affected in any way how crimes are looked at. I want you to think about that, and that'll be one of our discussion questions on the forum. Now, when we talk about appeals, we're not talking about, or case law, we're really talking about appeals. We're talking about cases that have gone beyond the trial stage, have been appealed by the defendant. If the defendant is acquitted, then the state can't appeal the case. You'll only see defendants who have been found guilty go up the ladder to the appeals court. The cases, when we talk about cases, what we're really talking about is opinions. We're talking about the judges or justices of the court ruling based on the law and the facts on what sort of procedure should have been applied to a criminal case, or what sort of substantive law should have been applied to a criminal case. And there are excerpts in the book, and we'll go over some of those excerpts throughout the semester. I guess I shouldn't have. Let's talk about definitions. Not guilty. It's very, very important that you recognize there is no such thing as found innocent. Why is there no such thing as found innocent? There's no such thing as found innocent because the presumption starts with innocence. It doesn't change until there is a guilty verdict. Once there's a guilty verdict, the person is guilty. So it's an on and off type of thing. Either you're already innocent or you're guilty. So when people say, oh, he's not guilty, he was found innocent, they're wrong. It's not the same thing. He was already innocent. He isn't found innocent. One could say he was found innocent throughout the entire trial. It isn't a point in time. It's something that exists until a guilty verdict. And if there's a guilty verdict, then the person is guilty. So do not say that someone is found innocent or that there was an innocent verdict. No. And there will be questions on this. Do not say found innocent. You're either guilty or you're not guilty. What one could say is that you're acquitted of the charges. First, you become an accused. At that point, and until you are found guilty, you are innocent. As an accused, you're innocent. Once you're guilty, you're guilty. If you're not guilty, you get to go free. Another word is acquitted. Another word for guilty is a conviction. Convicted of the crime. Nowhere in there is found innocent. Please